In this first module, we will explore the major laws governing the federal appropriations process. In later modules, you will examine these and how they are used. Other related laws are provided in the glossary and are treated in the companion courses on budget formulation and budget execution. Further detail, precedent, and discussion on all laws dealing with appropriations can be found in Title 31 on Money and Finance of the United States Code, OMB's Circular A11, and GAO's Principles of Federal Appropriations Law, also known as the Red Book. Let's start at the beginning with the Constitution. All federal authorities flow from the Constitution. Federal financial authorities are based on these three clauses of the Constitution. The first two clauses empower Congress with general authority to regulate the financial transactions of the United States. The third clause is known as the Appropriations Clause, and it is the basis for all subsequent laws governing federal appropriations. It is this authority that forms the basis of what we will cover in this course. Supreme Court cases, especially Reside v. Walker, have made the meaning of the Appropriations Clause crystal clear. Federal expenditures must be sanctioned by Congress. Congress decides what programs will be funded through passage of appropriation laws signed by the President. Congress has the authority to specify that funds may not be used for a particular program, which can effectively end the program. Congress can direct funds to a specific project or activity, sometimes with conditions. This is called an earmark. Congress can also attach certain conditions to the use of other appropriated funds. As a result, Congress has enormous power with regard to what gets done by the federal executive agencies. Before we look at the body of appropriations law, let's first look at what is required for Congress to enact an appropriation. It is important to understand the distinction between organic legislation, authorization for appropriations, and appropriations. Any funds Congress appropriates must be for a purpose that is defined in law. The legislation that establishes an agency or a program is called enabling or organic legislation. Congress has established processes to govern the provision of funds to support the agencies and programs established in organic legislation. As a general rule, Congress requires that appropriations be authorized first. There is no constitutional requirement for an authorization of appropriations. However, there are instances where specific authorizations of appropriations are required in organic legislation. Both the House of Representatives and the Senate have rules governing the authorization of appropriations. The authorization of appropriations does not constitute an appropriation of funds. In general, only an appropriation bill can do that. But an authorization can provide limits on the amount that can be appropriated, the purpose for which appropriated funds can be used, and the time period appropriated funds are available. We should note that for some programs, the authorization bill also provides the appropriation. Though this is not the norm, such programs frequently have sizable amounts of funding. The Budget Enforcement Act divided spending into two types, mandatory and discretionary. Mandatory spending means spending controlled by permanent laws. Discretionary spending is controlled by the Annual Appropriations Acts and provides most of the examples in this course. We'll cover this important distinction in greater detail in Module 2. As noted in the introduction to this course, an appropriation is a provision of law which permits the expenditure of a certain amount of funds for a given purpose over a certain time. It is the appropriation that provides budget authority, which is the authority that permits a federal agency to obligate the government to a future payment of funds. Regular appropriations are provided in a series of appropriations bills enacted each year. In many cases, not all of those regular appropriations bills are enacted by the beginning of the fiscal year. In those cases, one or more continuing resolutions are passed to provide funding for those agencies or programs included in bills that have not been enacted. Sometimes there is a need for additional funding during the fiscal year. A supplemental appropriation is enacted to provide funding for things like disasters or for new programs or additional program requirements. Each of these types of appropriations is treated in greater detail in the companion course on budget execution. Next, let's examine some of the major laws and rules governing the use of appropriations. The Anti-Deficiency Act, which is not a single act but rather a compilation of several distinct pieces of legislation, contains the most significant rules for governing the use of appropriations. This statute prohibits 5 things: making or authorizing an obligation exceeding an amount available in an appropriation, involving the government in a contract or obligation before an appropriation is made, making or authorizing an obligation exceeding an apportionment, making or authorizing an obligation exceeding an amount permitted by agency regulations, this is sometimes referred to as an allotment, and accepting voluntary services. The bona fide need rule states that the need for which the funds are appropriated must exist during the period for which the appropriation is made. Section 1301 of the U.S. Code, called a purpose statute, prohibits federal officials from using appropriated funds for purposes other than those for which the funds were appropriated. The application of these are discussed later in Module 3. There are other laws governing appropriations and budget execution. The glossary accompanying this course contains a listing of those. Now let's summarize what we've learned. In this module, we have covered the constitutional basis for appropriation law. These are the major points you should take away from this module. Congress has the power of the purse. Organic legislation creates programs and agencies. Appropriations are needed to obligate the government to future expenditures, and there is a body of laws and rules governing the legal use of appropriations.